based on what is commonly known and based on expert testimony before the committee, is the key medical predictor of whether an unborn child is going to reach live birth. And of course, it's the clearest evidence of human life, isn't it? Think about your earliest memories of your mother's heartbeat. Think about that loved one in the hospital and that heart monitor. We all understand intuitively and scientifically that the heartbeat is the measure of life. And so Senate Bill 8 will protect that little unborn child in her mother's womb once that heartbeat is detectable. 11-0, the states have already passed heartbeat bills. Texas is behind. This bill, we believe, is drafted differently. We believe better, more effective than those. Those bills are wending their way to the U.S. Supreme Court. We believe this bill is superior in ways we'll get to discuss today. It's also important for us to remember that often we miss that Texas has never impliedly or expressly repealed the statutes that prohibited abortion unless the mother's life is in danger that existed decades ago. Those statutes have never been repealed. Senate Bill 8 protects the lives of the unborn children by prohibiting abortions after that fetal heartbeat has been detected. It requires the physician to determine whether there is a heartbeat. And if a heartbeat is detected, the physician cannot knowingly perform or induce an abortion, and he can be held civilly liable unless there's a medical emergency. And as you know, that's already well defined in statute in this context. Performing an abortion outside the parameters of this bill in violation of the chapter and aiding and abetting an illegal abortion is all subject to private civil enforcement once this bill takes effect. It includes a legislative finding establishing that the state of Texas has never repealed expressly or impliedly, again, those statutes enacted before Roe, which prohibited abortion unless the mother's life was in danger. And finally, the bill makes it clear what has to be in the pregnant woman's medical record. This includes why the abortion was performed. If a physician performs under the medical emergency exception, the reasons for that must be noted. I will be offering a floor amendment, assuming that the Senate sees fit to let us suspend and bring this bill up. I'll have a floor amendment which, with a little more clarification, which I'll discuss at that point. And I would move suspension and yield for your questions.
Senator Menendez, for what purpose?
Thank you, Mr. President. I had questions for the author of the amendment, but I guess the first question is most important is does the amendment...
Excuse me.
Yes.
We're not on the amendment.
Sorry.
We're on suspension of the regular order. You may ask questions about the bill and then ask questions about the amendment.
Ask questions about the bill then, if it's okay, Mr. President?
Yes, sir.
So, thank you.
Do you yield, Senator Hughes?
Of course I yield, Mr. President.
Thank you, Senator Hughes. You said in your bill layout that this is about the detection of the heartbeat, but is there a timeline or a date or a number of weeks that this bill says that it's the cutoff for when a woman can seek an abortion?
Senator, this is based on the detection of the heartbeat. And so I bet you know from experience, and experts have told us, that the fetal heartbeat is detectable at different stages for different babies, for different mothers. So rather than set an arbitrary line, this looks at each individual case. And when that little baby's heartbeat is detectable, that's when she's protected. So it doesn't set an arbitrary number of days or weeks.
So your bill would require a woman, if she wanted to seek an abortion, to first get a doctor to see if there was a heartbeat or not a heartbeat?
Essentially, it requires the doctor before performing the abortion. So a woman seeking to terminate a pregnancy would go through the normal processes in law today. The requirement would be on the physician to check for a fetal heartbeat before proceeding. So it doesn't put any extra steps for the mother at all.
Would your bill allow any person, even if they're not connected to the patient or impacted by the results of an abortion, to file suit against the doctor or anyone who, quote, aids and abets the procedure?
Yes, it would. Just like we do for civil Medicare, civil Medicaid, and other key TAM provisions for Senate Bill 1978 from last session, it would give standing to any person other than the government. So a government employee, a government actor could not do this, but any private citizen would have the right under this bill to bring that cause of action.
So now anybody would have standing other than the government, is what you say?
Except government actors, that's correct.
Is there a definition for aid and abet?
There is. Aiding and abetting is defined, and it has a knowing requirement, right? So it has to be someone who knowingly does. There's also an affirmative defense in there, and the standards of proof are there to make sure no one is caught up unnecessarily in that. So there's a knowing requirement, and there are defenses for that.
Okay. So, Senator, what if a woman is experiencing a miscarriage or needed to have this procedure done in order to prevent a serious damage to her health or save her life? Would this tie the hands of the doctors or make them subject to a lawsuit simply for treating their patient?
It would not, and I would point to you existing law 171.002, the Health and Safety Code. Medical emergency means a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that is certified by a physician, places a woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. That's, the legislature passed that some years ago. That's been tested in court. Docs have testified about that. So that medical emergency exception is specifically provided for in the Texas Heartbeat Bill.
Senator, is there a fiscal note affiliated or associated with this bill?
Senator, a number of the pro-life bills that were considered had questions about fiscal notes because, believe it or not, there was a discussion about whether more babies being born would be a cost to the taxpayers. I know that's not what you're talking about. We are for more Texans being born. To my knowledge, the Nelson Amendment was placed on this bill in the process to make sure, but I'm not aware of any fiscal implication to the state. And here's why I would say that. There is no state action in this bill. This does not compel or allow the state of Texas to take any action. This is about private enforcement.
It's about suing a doctor or anybody who aids and abets a woman if she has an abortion prior to or after the detection of a heartbeat. Who would determine? I mean, I guess I'm trying to figure out a fact pattern for how this would go down the road.
So the law requires, if this law passes, and by the way, the experts tell me to make sure I'm clear, there is no fiscal note on this bill, no fiscal impact, whatever. I was talking about some other bills, but so we're clear, no fiscal impact. Practically speaking.
Are you sure if there's a fiscal impact?
I beg your pardon?
Is there a fiscal impact?
There is not. Thank you.
Just checking.
Thanks for helping me clarify that. As far as the process goes, the law requires that a physician, before performing the abortion, check for that heartbeat. And if a heartbeat's detected, to stop there. So questions about enforcement, we could talk about the state in other pro-life bills. There's always going to be questions about proof and about enforcement. But so many of these things happened in the abortion clinic, and that's not changing.
So do you think, my understanding is other bills that have passed in other states like this one have been found unconstitutional. Do you feel that we're working on a bill that's eventually going to be unconstitutional?
We believe this will be upheld. Again, those other bills, 12 or so that are working their way to the U.S. Supreme Court, they all provide for government enforcement, for criminal sanctions against physicians who violate the law. Right. Each one of those bills was enjoined before it ever took effect. Someone brought suit and enjoined them, and so they were stayed pending ruling by the Supreme Court. We believe this bill will be upheld, and we believe it'll be upheld by the U.S. Supreme Court.
So this bill literally creates a new cause of action.
It does.
So cause of action. Is this the first cause of action we've created here in a while?
In Senate Bill 1978, last session, we created a cause of action for those people whose religious freedoms were being trampled by, being affected by the state. There was, I guess, a cause of action for barratry. I think maybe TLR and TTLA kind of got together on that one. So creating a cause of action is not something the legislature does lightly, but it is something we do.
Thank you very much, Senator. Thank you, Mr. President.
Thank you, Senator.
Senator Johnson, for what purpose?
Questions of the author?
You yield.
Of course, I'll yield.
Thank you, Mr. President. Thank you, Senator Hughes, for engaging in this discussion. Let's just see if we agree on one thing up front. We agree on a lot of things, but on this topic, we don't agree very often.
That's right.
But can we agree that if a bill were introduced right now that outright bans abortion, that bill would be unconstitutional under the current law of the land?
Under the current Supreme Court interpretation of the Constitution, yes, that's correct. I believe that's right.
Thank you, Senator Hughes. And the way your bill works is that if a woman seeks to have an abortion, she must go to the physician and have the physician try to detect whether or not there's a fetal heartbeat.
To make sure we're clear, I wouldn't want to give the impression that this is a separate trip. The requirement is on the physician before performing the abortion to check for a fetal heartbeat.
Very good. Thank you for the clarification. So I want to zoom out again. You've included in your bill something that's a little unusual. You've included, quote, legislative findings, right? Why did you put legislative findings in the bill? Is that to make sure that it upholds or stands up to a constitutional challenge?
Well, Senator, as you know, the answer is yes, in part. It's not uncommon for us to include findings in bills. Let's give the courts the benefit of the doubt. Let's say that they are trying to discern legislative intent and trying to apply the law to a bill that we pass. And so the findings help a court. You know, you and I could testify after the fact, here's why I voted for that. Some courts listen to that, some don't. But when the legislature finds in legislation, then those findings have a greater weight and it gives the court some guidance. So yes, that's why we're including findings. Not unusual for legislation to have findings.
For clarity, I guess, for the...
Yes, sir.
You've come to clarify. So let's go through the findings a little bit. Finding number 1, a fetal heartbeat has become a key medical predictor that an unborn child will reach live birth. What do you mean it has become a key medical predictor? Is that a recent thing? That we just figured out that if a baby doesn't have a heartbeat, it's unlikely to be carried to term?
Since Roe versus Wade in 1973, medical science, technology has come a long way. In terms of viability, little babies that would not have lived outside the womb in 1973 today can. But to your specific question, yes, the testimony before the committee was that that fetal heartbeat, the presence of that fetal heartbeat tells us with a 95 to 98% certainty that the little baby will come to term. So yes.
Right. And so the absence of a fetal heartbeat would suggest quite the opposite, right?
So the presence of a fetal heartbeat is a very strong indicator. The absence is the absence of...
The absence of a fetal heartbeat says this pregnancy is not going to term with a live birth, right?
It's the absence of that indicator. We didn't have testimony on what the other indicators might be, but we know that a heartbeat is a very strong indicator. That's all. I wouldn't want to go beyond what the testimony we heard in committee, but that's why this finding is
neither
here.
One of us went to med school, but do you feel comfortable saying that if there's no heartbeat, there's unlikely to be a live child born from that pregnancy?
Depending on the stage of gestational development, that makes sense to me.
Okay. So what we've got here functionally is a bill that says if there is a heartbeat, you can't have an abortion, even though it's your constitutional right. But if there isn't a heartbeat, and you wouldn't need an abortion because there's not going to be a live birth, well, that's fine. So effectively, you've completely removed the right to an abortion when somebody might actually need an abortion, haven't you?
I think you lost me on one of those steps. Go one more time.
I'm saying that there's two circumstances. There either is or there isn't a heartbeat. And under your bill, if there is a heartbeat, the constitutional right to an abortion is cut off. And we can sort through the courts whether or not that's a constitutional move by this legislature. But under the other scenario, if there isn't a heartbeat, well, I guess you can go ahead and have an abortion under your bill, even though there's not going to be a live birth. So effectively, you're telling women who right now have a constitutional right to an abortion that in the event you might need one, you can't have one.
Well, Senator, we had a similar discussion a few sessions ago with the Prenatal Protection Act, the bill that says at 20 weeks, when medical science tells us the little baby can feel pain, at that point, the abortion would not be allowed. We had the same discussion then, and it's an important discussion to have. I'm not minimizing it. But yes, that's what we're saying. We're saying when there's a heartbeat present, the state of Texas is saying that's a human being deserving of protection. We're going to protect that life. So
I just don't think it's anything like the 20 weeks, but we've made a record for this point, so we'll move on. Second finding. Cardiac activity begins at a biologically identifiable moment in time, normally when the fetal heart is formed in the gestational sac. Now, according to my very amateur non-medical research, that's false. that the heartbeat is detectable perhaps as early as 21 days as an electrical impulse, not when the fetal heart is formed in the gestational sac. So your bill doesn't try to, as you explained with Senator Menendez, doesn't prescribe a specific day, right? Because it's difficult to prescribe a specific day. But it also requires that the physician use means calculated to be able to detect the fetal heartbeat at that gestational stage. So if a woman goes in at 3 weeks and a day of gestation, when there's an electrical impulse, is the physician required to use the most advanced technology available to detect that electrical impulse? And would that be the day at which she loses the constitutional right to control her own reproductivity?
So the physician under the bill is required to use reasonable medical practice. And so it doesn't specify whether a stethoscope or a sonogram. The physician is directed to use her best medical judgment to check for a fetal heartbeat. And a heartbeat, of course, as is described, that steady rhythmic heartbeat.
So it could be as early as 3 weeks.
That's not consistent with the testimony we heard before the committee, but I'll defer to you on if there's doctors who say that.
Well, it is a medical fact that the heartbeat can be detected before the fetal heart is formed in the gestational sac, that cardiac activity anyway. So that finding, I would not be comfortable with this legislature adopting a finding that's contrary to medical fact.
And I would just say that based on the medical testimony before the committee, that the findings are consistent, but we may differ over that, I realize.
Very good. The third finding, Texas has a compelling interest. Now, compelling interest, it sounds like we've just told the court they don't need to do their job, because you and I are lawyers, and we know that when we examine state action that interferes with constitutional rights, the standard is always, did the state have a compelling state interest? And that's precisely the question we bring to the courts. Don't you agree with me that we as a legislature aren't empowered to find our own compelling state interest, that the courts have to find that?
Oh, Senator, I believe we are duty-bound to define that interest. Again, this is about telling the courts why we're doing what we're doing, and that they're going to make their judgments based on the law and hopefully the Constitution. But I think it's important that we tell the courts why we're doing it. And as you know, my goodness, going all the way back to 1989 in Webster versus Reproductive Services, Casey in 92, and since then, the Supreme Court has consistently given states more and more latitude to protect unborn life. They were calling it potential life. More recent cases talk about the interest in protecting fetal life. So clearly, it's important to the people of Texas, and it's about life. So, of course, it's a compelling state interest.
But you don't think the courts have to take our word for it, and we say, hey, we think we have a compelling state interest. Courts, never mind your analysis. We've taken care of it. We can't do that, can we?
Well, the courts will apply the analysis they'll apply, but we want to give them every opportunity to do the right thing and make it clear this is important to the people of Texas.
Let them know that at least we think we have a compelling state interest.
That's right.
Okay. And that compelling state interest, and finding number 3, is that from the outset of a woman's pregnancy, the state has a compelling state interest. That means at conception?
The Supreme Court talks about potential life. It talks about unborn children. It talks about fetal life. So again, we could go back and you've read those cases. And over the years, each time the Supreme Court's looked at this, they've further recognized the rights of the unborn child in the womb. And that's what this is about. Now again, this bill says when the heartbeat is detectable, that's when we'll protect the little unborn baby.
Right, but your compelling state interest says from the outset of the pregnancy, and I'm just wondering if we have a philosophical or a religious element here in the bill that isn't so medically, scientifically definable.
Even if we disagreed on when life begins, the Supreme Court has made it clear that potential life, unborn children in the womb, that the state has a legitimate interest in protecting that life.
Okay, so we've got the compelling state interest from the outset of a woman's pregnancy in protecting the health of the woman. How long does that compelling state interest last? When does it cease?
With regard to
when
an
do we
individual,
no longer have a compelling state interest in the health of this woman?
With regard to an individual unborn child, or do you mean,
well,
I'm sorry, help me understand.
Well, the health of the woman and the life of the unborn child are separately identified. So how long do we have a compelling state interest in protecting the health of the woman? Until she gives birth, or later than that?
In the context of this bill, is the little unborn baby who's growing inside her mother. Is that what you're asking? I'm not sure if I follow you.
It just seems to me that we exert our compelling state interest so long as it's convenient. And as soon as she gives birth, we no longer find such a compelling state interest, which is why we allow them to qualify for Medicaid up to 204% of the federal poverty level while they're pregnant, but it drops to 16% once they give birth or 2 months after.
We are going to hear some other legislation today that talks about support, resources for mothers in these processes, in this difficult process. So I look forward to having that conversation too. This bill is about the little unborn child and what her rights are, but we're going to have some important legislation making sure those mothers are supported, come alongside, encouraged, and helped in tangible ways as well.
Okay, thank you. I'll accelerate along to the stuff you and I know a little bit more about, which is the law. Talked to Senator Menendez about AIDS or abets. And
Senator, can you hold your mic up so everyone can
I'm sorry,
hear?
thank you, Mr. President. Don't want to make the place echo, but here we are. Tell me more about what AIDS or abets mean, because I'm wondering if someone gives a ride to a woman to go see the doctor or to go for an abortion service, have they aided or abetted the process? Are they a defendant?
Senator, under this bill, a person in that situation, and you know, the affirmative defense is, you've probably seen that language, this is not about an abortion, but about an illegal abortion. And so if one were to aid a woman in getting an abortion in violation of this law, that is to say, without the doctor checking for the heartbeat, then that would be aiding and abetting, but not for abortions generally, only abortions that would be in violation of the statute.
So only for abortions where a heartbeat has been detected, not for abortions where we know there's no heartbeat.
Only where the heartbeat's
That would
been
be a
detected.
legal abortion, right?
The doctor would have to check for the heartbeat, and then if there's a heartbeat, not move forward. That's what the law would require. So that's the type of abortion prevented by this bill.
So if a mother pays for her daughter's abortion, she's amenable to suit, isn't she? If it's an abortion not of a baby without a heartbeat, but if it's an abortion where there is a heartbeat detected in the developing child.
As you know, it depends on what her intent was and what she knew. And so it's not a strict liability standard.
She knows.
It's not a strict liability standard.
She pays the cost of her daughter to have an abortion at 8 weeks, and a doctor has detected a heartbeat. She's liable?
Senator, if a doctor has detected a heartbeat and the abortion goes forward and that was her intent, yes.
Right.
And that would be an unusual circumstance. But if that were the case, that's under this bill, that would be aiding and abetting.
Senator Hughes, what county do you live in?
I beg your pardon?
What county do you reside in?
Wood County.
Which one?
Wood
County. So if you learn of that mother who I just mentioned in my hypothetical example, driving her child to the physician, paying for an abortion at, say, 8 weeks after a fetal heartbeat has been detected, and she lives in Comal County, you individually could sue her in your county even though she doesn't live there, couldn't you?
Could. Now, the likelihood of something like a fact pattern like that is pretty hard to imagine. But as I read the bill, if all those things were true, that could happen, yes.
It's unlikely that we would have a snowstorm with freezing temperatures for a week, but we had one. It may be unlikely that somebody from a remote part of the state would sue somebody else on account of their personal decisions in the exercise of their current constitutional rights, but it could happen, and we're setting up that situation right here.
Senator, this bill says for the little baby inside her mother's womb, if there's a heartbeat detected, that little baby will be protected. I want to be abundantly clear about that. You're correct.
Well, the bill doesn't say little baby.
I beg your pardon?
The bill doesn't say little baby.
Forgive me. I'm sorry. The phrase is unborn child. I'm from the country. Unborn child is the term in the
I don't mean
statute.
to really. It's a difficult thing to talk about because people have a profound appreciation for life, whatever their view is on reproductive rights. And so I don't mean to quibble unnecessarily, but I think we are taking a really fundamental, philosophical, sometimes religious, moral question and legislating it way past anything that's ever been upheld by the courts or that anybody has ever really thought of being the right thing consistent with the law before today.
Well, Senator, before Roe versus Wade, the criminal statutes regarding abortion were consistent with this. Aiding and abetting was there. And again, and even then, Texas recognized, of course, the protection of the life of the mother. But to suggest this is some radical departure from the law is really taking a very short view of history. And ever since Roe versus Wade, given the opportunity, the Supreme Court has, we could say, chipped away, has shrunk, has hollowed out Roe. I mean, we'd have to agree with, surely we'd agree on that. And based on statutes like this that find their way to the Supreme Court.
I suppose you're right. It could be that we're actually just sending ourselves back a half a century to what the law was before Roe versus Wade.
Well, Senator, we'll get to, you may want to talk about that. Those statutes, of course, that were limited in their enforcement by the Supreme Court in 1973 are still literally on the books. But this bill, of course, is about the heartbeat. This is not going back to exactly what the law was before Roe versus Wade.
You also have an attorney's fees provision here in the bill, right?
Yes.
What does that do?
The attorney's fees, it provides attorney's fees to the person who brings an action and prevails.
So like the person in Wood County who sues the mother in Comal County.
Senator,
gets her
fees. I'm sorry. Go ahead.
Well,
like in a Ketam case, like in the DTPA, right, where we create an army of private attorneys general. You're familiar with that concept.
I am.
Private civil enforcement is one of the ways. And I'll just say, you may have seen this, but I want to commend to you an article that came out in October, and it publicizes a letter signed by attorney generals from all across the country, 4 or 5 of them in Texas. And they reference heartbeat bills that are making their way through the courts. And each of these district attorneys and some state attorneys general say, if these heartbeat bills pass, we're not going to enforce them. This letter is signed by district attorneys in Dallas County, Bexar County, Nueces County, Fort Bend County. Now, we don't know what the view of other DAs is, but these DAs have told us, pass a heartbeat bill, we're not going to enforce it. Senator, private enforcement, what else is left to us if the elected DAs are not going to enforce the law?
And I understand the wisdom of trying to make your bill go through private enforcement rather than leading public officials who don't want to enforce an unconstitutional bill. I understand that. And the analogy to Ketam, I'm glad you brought it up, because that makes private citizens attorneys general, right? To enforce something that affects us all, namely, in the Ketam cases, these people are scamming the federal government and taking our tax dollars. So we all have an interest in catching those bad actors. As contrasted with this is private, personal, legal, constitutionally protected behavior, and we're setting loose an army of people to go sue somebody under a bill that will likely be held unconstitutional. I know you think it will be held constitutional. When we don't know whether it will be, and you're saying that the defendants are going to have to pay the attorney's fees when they lose their case, and they most certainly will, because your bill's pretty clear, it's well drafted, but you also said they couldn't assert as a defense that your bill is unconstitutional. So for the next couple of years, they can't defend themselves. They could be sued over and over and over again, having to pay $10,000 every single time. And for years, while it winds its way through the courts, they can't afford to defend themselves. So effectively, you have shut down their medical practice and completely destroyed the constitutional right to control your reproductivity.
Senator, as you know, the current Supreme Court standard is undue burden. A law cannot place an undue burden on a woman seeking an abortion. That defense is specifically set out in this statute. And as you know, anyone who's sued under this can challenge the constitutionality of it if they're sued under this.
But it's not a defense. Or did I misread your bill? Because I think I read in your bill that the unconstitutionality of this is not a defense that that mother who drives her daughter to the office can assert. It's specifically...
Well, Senator, anyone who's sued can seek relief in court, so that's. I want to make sure we're on. Are we talking about pre-enforcement injunction against the law taking effect? Or are we talking about the lawsuits that could be filed under the statute? I want to make sure I'm following.
Well, I may have misread your bill, but I thought I saw in here that the defendant cannot assert the unconstitutionality as a defense to one of these private lawsuits.
No, sir. That's. No one could deny that. Now, we believe the way the bill is drafted, as far as this pre-enforcement litigation, there is no state defendant. There's no state action here, and the Fifth Circuit law is pretty clear on that. And so that's one thing. But we certainly aren't. Again, I'm not sure I understand what you're saying.
Well,
one more time.
Well, let's just go back.
I apologize. Maybe we're not reading it the same way.
As a practical matter, how is any physician going to stand up to an avalanche of $10,000 claims when they have to pay the attorney's fees on the other side when your bill is prescribing them from doing what it is their practice to do? How can they possibly continue to function?
Senator, if the legislature passes this law, passed by both houses, signed by the governor, the intent of this law is to say when the unborn child in her mother's womb has a detectable heartbeat, her life's going to be protected. That's the intent of the bill. I hope that's clear. That's the intent of the bill.
That's clear. So I'll sum up here. You've got legislative findings that I don't think are factually correct, that I don't think are supportable, that I don't think are within the authority of this body, that support your bill, so I don't think your bill's supportable there. I think it makes a mockery of the rights of individuals to carry out their professional practice by deputizing the whole state to sue them for a private personal constitutional decision. I think it's a really sad encroachment on our constitutional rights, and I understand the passion that you have behind this bill, and it's shared by many people, and with all due respect to that, I think those are personal, philosophical, religious decisions, not the scope of big state legislation, which is, I feel, what's going on here. Thank you for the respectful dialogue.
Thank you, Senator.
Thank you, Mr. President.
Senator Hancock, for what purpose?
To ask the author a question.
Do you yield?
Of course, I'll yield.
Yes, thank you, Senator Hughes. And I just wanted to interject because I heard the conversation you had with Senator Johnson, and at one point there was discussion about not hearing a heartbeat. And you had referenced a bill that would be coming up later, did you not?
Yes.
You know what that bill is in regards to?
Yes, sir.
I'm going to say it because it's prenatal palliative care. Is that
exactly right?
The one you're referencing?
We're looking forward to hearing that bill, Senator. Go ahead, please.
Well, and so my point is that I wanted to interject is during that bill layout, you actually heard testimony from a mother who, expectant mother, right? Had an unborn child, went in as she'd gone in for her regularly scheduled visit. The heartbeat was not there. She went to prenatal palliative care. And I'll finish the rest of that story because it was told in your committee with that child sitting beside her mother. And so I wanted to point out that, I think you were focused on your legislation, but we do have times where the proper discussions that prenatal palliative care allows, that just because you may go in and not hear a heartbeat doesn't mean that you don't have an unborn child waiting to enter the world.
Senator, that's right. That was really moving testimony, and I hope you will tell us. You're exactly right. We can't miss that.
I didn't want that to go by because it sounded like, they don't have a heartbeat, then that's the end of it. I think if we pass legislation this session, it may not be the end of it for some of those unborn children.
That's right.
Thank you.
Thank you, Senator.
Senator Lucio, for what purpose?
Senator Hughes, yield, please.
Do you yield?
Of course, I'll yield.
I don't think it's a big secret that I cherish life, and I am against abortion of a living child that's still in the womb of the woman. And for those of you who, and I don't want Senator Johnson to take this negatively against him because I have a great deal of respect for this young man. I've said it more than 2-3 times. I said it a while ago when we were debating the power bill, that you're one of the brightest minds I've ever seen. Senator Nelson agreed with me. But for you to use the word mockery, it offends me because I stand firmly by the side of this author of this wonderful bill that I will be talking about in the next few minutes. I think, if anything, to stand for abortion really makes a mockery of the sanctity of life. I want to say this. I've gotten a lot of phone calls, especially and notes from one of them from the Catholic Conference of Bishops that I follow real closely, Senator, Mr. Chairman. And this is the quote that I find in that note. It says, quote, "The right to life is the first human right. Abortion is killing someone that cannot defend him or herself. And that they quote Pope Francis, along with Rabbi Abraham Sorka, I believe, in his book on heaven and earth. I'm going to be asking you a series of questions, but they also, in those notes, add Deuteronomy 30 and line 19. This day I call the heavens and earth as witnesses against you, and I have set before you life and death, blessings and curses. Now choose life so that you and your children may live. That's so important for me to be able to receive from those that I depend on spiritual guidance and guidance in the faith that I belong to. Chairman Hughes, I know we heard testimony that this bill will not be upheld in court, and that was a little bit, in the debate a little while ago, that was brought up. But when writing this legislation, did you worry more about the courts or the heartbeats of the unborn babies?
Senator, that's right. This is to protect that little baby when a heartbeat is detected. That's right.
As an equal branch of government, the judicial branch has the ability to strike down legislation. We know that.
Yes.
They have the authority to do that. When I look at legislation, I think about how it would affect those in my district and across Texas. So I'm the same as you on that with this bill.
Yes, sir.
I want to ask you about what we heard in committee. I think the most memorable witness was the one that played the sound of the heartbeats. Remember that?
I remember that.
Were you able to distinguish a difference between the two?
Senator, that's right. She played one heartbeat that was from a little baby about 6-7 weeks and another at about 20 weeks. And they were little heartbeats. None of us could tell the difference listening to them. That's exactly right.
Well, I wasn't either. I wasn't able to. Do you think one heartbeat deserves to be protected while the other one is not?
Senator, they both deserve protection. That's right.
I would like to add that there's bills that have been passed here. The Sonogram Bill was an incredible bill authored by Senator Dan Patrick back in 2011, I think. I certainly want to add that to the list of good bills that we have addressed that actually honors our Maker. A while ago, we did everything we could to honor those that represented our country in uniform, and we honored them by praising them for their patriotism and everything they do. And nobody likes war because there's death. In your bill, we're trying to preserve life the way I see it.
That's right.
I'd like to add a little psalm myself, with Psalm 139, 13 through 16. It says, "For you created my inmost being. You knitted me together with my mother's womb. I praise you because I am fearfully and wonderfully made. Your works are wonderful. I know you fully well." I just feel very strongly about, what we're doing here with your bill, and I commend you for working on it. And we can disagree. I believe that life really starts at conception, not with a heartbeat, but at conception.
Yes.
At conception. to natural death, not death by lethal injection or any other means, murder. So I thank you for your work on this bill, and I'm glad that I was able to work in committee to move its passage onto this floor. But I would ask for all of us to just take a moment and think about how much we truly love, the people, our families. In my case, 5 grandchildren, 100+ cousins, and all my friends, so many of them. I have a profound appreciation for life. I really do. And that's something that's very sacred. And, today we have mourned the loss of our loved ones across the state, and also, as I mentioned, supported men and women who have defended our country in time of war. I don't think they're proud of killing anyone when they come back. They suffer emotional and mental distress. I support them. I pray for them. And I hope that we can come to grips on who we are. We're God's creation, and we should do everything we can to sustain that life. Thank you.
Thank you, Senator.
Thank you, Senator Lucio. You're recognized to suspend the regular order of business.
President moves suspension of Senate's regular order of business.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Schwertner, Seliger, Springer, Taylor, West, Whitmire, and Zaffarini.
There being 19 ayes and 12 nays, the rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 8. If the Secretary will read the caption.
Committee substitute Senate Bill 8 relating to abortion, including abortions after detection of an unborn child's heartbeat.
Members, there is an amendment. The Secretary will read the amendment. Read the caption.
Floor Amendment Number 1 by Hughes.
Senator Hughes, on your amendment, you're recognized.
Thank you, Mr. President. Members, the floor amendment was distributed to your offices when we got it prepared. Incorporates perfecting language, and it clarifies a couple of provisions of the bill. Let me just tell you briefly about it. The bill provides for injunctive relief, but the way it was drafted before, there was a gap, and so this as a doctor can be enjoined from performing an abortion in violation of this law based on intent, which makes sense for injunctive relief, which goes forward. It also establishes that affirmative defenses, like we were discussing with our colleague from Dallas County, Senator Johnson, affirmative defenses can be proven by a preponderance of the evidence, which is just the greater weight of the credible evidence. It's the normal standard in a civil case. Also nails down venue where it's filed, as Senator Johnson and I discussed. It also puts some more clarity in the severability section. You'll recall that's what says if a court takes exception to part of this statute, it would make it clear that the rest of the statute would take effect. And also, it makes it abundantly clear that this bill will be enforced only through private civil enforcement, not by the state, not by the commission. And there's one addition to the floor amendment we filed that's a little different than what we sent to you. And we found one more place in the bill with a reference to the commission. And so this amendment makes it clear that the Health and Human Services Commission in the state of Texas does not enforce this bill. It's purely private enforcement. I think whether we like the bill or not, I think we'll agree that's all consistent with the original purpose of the bill. And I move adoption of floor amendment number 1.
Members, questions on the adoption of the amendment? Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Schwertner, Seliger, Springer, Taylor, West, Whitmire, and Zaffarini.
There being 19 ayes and 12 nays, the amendment is adopted. Senator, you're recognized on passage on engrossment.
Mr. President, thank you. Members, thank you for the time devoted to this. That little baby, that little unborn child growing inside her mother's womb is never going to be more helpless, never more innocent, never more deserving of our protection than she is in her mother's womb. We all know what that heartbeat means. We know it intuitively. We know it scientifically. And this bill says Texas will protect our most vulnerable Texans when the heartbeat is present. I move passage to engrossment.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Schwartner, Sulliger, Springer, Taylor, West, Whitmire, and Zaffarini.
There being 19 ayes and 12 nays, the bill passes to engrossment, and we will hold there until tomorrow. Thank you.
Thank you, Mr. President. Thank you, members.
Senator Hancock, you're recognized on motion to suspend the regular order of business on Senate Bill 1173.
Yes, thank you, Mr. President. I move to suspend the regular order of business, take up and consider Senate Bill 1173 at this time relating to the regulations of abortion, including information regarding perinatal palliative care and prohibiting the discriminatory abortions, authorizing disciplinary action, providing a civil remedy, creating a criminal offense. Members, of the state of Texas currently has no laws in place to prevent discriminatory abortions performed due to race, ethnicity, sex, probable diagnosis of Down syndrome, or probable diagnosis of severe disability of a preborn child. While House Bill 2, as passed by the 83rd legislation, prohibited abortion in Texas after 20 weeks of pregnancy in most cases when preborn children are proven to feel pain, it also formed a loophole allowing an abortion to be performed at any time in a pregnancy, even late term, based on the diagnosis of severe abnormality. When a diagnosis of a severe abnormality or disability or of a preborn child is determined, abortion is not the only option. Even in the most heartbreaking cases, when a baby is unlikely to survive very long outside the womb, perinatal palliative care programs exist to care for both the child and the family. Unfortunately, many parents are not aware of these services when faced with such difficult diagnosis. Senate Bill 1173, the Preborn Non-Discriminatory Act, adds language to the Health and Safety Code related to the perinatal palliative care and discriminatory abortions. The bill requires that the perinatal palliative care information be provided to pregnant women in the time of diagnosis of severe disability of the baby so the woman may make a fully informed decision regarding her pregnancy. These informational materials will be maintained by the Health and Human Services Commission, including information about medical assistance, benefits available to the perinatal care, childbirth, and perinatal palliative care. The legislation also prohibits discriminatory abortion on the basis of race, ethnicity, sex, diagnosis of Down syndrome, and diagnosis of disability of a woman's unborn child. A violating physician commits a Class A misdemeanor, is open to civil action, and may have his or her medical license revoked. It is important that women on whom an abortion is performed or attempted in violation of the Act is expressly protected by this bill against any criminal penalty. Additionally, the legislation maintains the current medical emergency exception for abortions necessary to prevent the death or substantial risk of a serious impairment to health of the woman. Finally, the particular bill does not regulate abortions performed earlier than 20 weeks post-fertilization unless the abortionist learns the purpose of the abortion is purely discriminatory nature. Members, I would like to call all to agree on discriminatory against any human being based on race, gender, or disability is never okay, even in utero. Permitting such discriminatory borders in are truly reprehensible. Before I move to suspension, I would like to put a face on it, let's say. So I'd like to tell you the story of Elisa Fish. Elisa Fish brought her daughter, Camille, at multiple medical appointments throughout her pregnancy. Elisa was warned that Camille had a serious genetic condition and could be stillborn or put Elisa through great health risk during the pregnancy if it continued. Elisa is a military veteran, and her active duty husband was away in Afghanistan during the devastating time. Setting aside the doctor's recommendations to have an abortion and researching for her help on her own, Elisa found a perinatal palliative care organization that provided emotional support as she faced PTSD, depression, which you can imagine, during such a challenging time. Members of Elisa stood strong, and the doctors were wrong. Camille was born very healthy and at term. She does have a genetic condition, but it does not significantly impact her quality of life, and she has not missed any developmental milestones. Camille is currently 13 months old and came to see us here in the Senate chamber during the mom's testimony. She is fearfully and wonderfully made. With that, I move suspension.
Thank you, Senator Hancock. Members, the motion is on suspension of the regular order of business. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Sulliger, Springer, Taylor, West, Whitmer, and Zaffarini.
Members, there being 19 ayes, 12 nays, rules suspended. Chair lays it on second reading. Senate Bill 1173. The Secretary will read the caption.
Senate Bill 1173, relating the regulation of abortion, including information regarding perinatal palliative care.
You're recognized on passage to engrossment.
Yes, thank you, Mr. President. I move passage of engrossment, Senate Bill 1173.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall.
There being 19 ayes and 12 nays, the bill passes to engrossment. And we will hold there. Thank you, Senator. Senator Nelson. You're recognized as committee substitute for Senate Bill 64.
Thank you so much, Mr. President. Members, I move to suspend the Senate's regular order of business to take up and consider at this time the committee substitute to Senate Bill 64. Senate Bill 64 creates a peer counseling program for law enforcement officers who are at increasingly high risk for suicide, depression, post-traumatic stress, and other mental health challenges. In 2019, 19 Texas officers took their own life. Across the nation, 228 officers died by suicide, nearly double the number killed in the line of duty. Specifically, this bill directs the Texas Commission on Law Enforcement to develop a peer support system. It allows the commission to contract with an institution of higher education with expertise in mental health or law enforcement to carry out training hubs. And it specifies that the training covers suicide prevention and ensure law enforcement officers have support in both urban and rural jurisdictions. Members are law enforcement officers face enormous risks and witness unspeakable trauma on the job. They are much more likely to open up and talk about these issues with one of their own colleagues, and that is why a peer support network is so critically important. Police officers put their lives on the line to keep us safe. They need our support, and because of the sacrifices they make on our behalf, they deserve it. Mr. President, I move suspension on the committee substitute to Senate Bill 64.
Senator Hinojosa, for what purpose?
Senator, yield for a question?
You yield.
Absolutely.
Senator Nelson, this bill sounds familiar to other bills you passed to provide this type of support in different areas. Could you elaborate on that?
Yes, Senator, I think it was 2 or 3 sessions ago, I had, and with your support, we passed a peer-to-peer veterans support bill. Very successful. In fact, many other states have created similar programs. And no one understands, as you well know, understands what a veteran has gone through better than another veteran. And so the counseling that the peer-to-peer veterans programs have undergone, those counseling programs have proven very successful. And we believe that peer-to-peer counseling with our police, our law enforcement, will also prove very successful. What they go through daily is just unimaginable. And as I said in my layout comments, unfortunately, suicide incidents have grown, mental health problems have grown, and our law enforcement, I think these peer-to-peer support groups will be very helpful in what our law enforcement needs right now for their mental health.
And I agree. I think the peer-to-peer counseling system was set up for veterans to be very successful. Yes. And certainly our law enforcement and police officers also are exposed to many risks in their life on a daily basis. We just had another DPS officer shot this weekend. So those type of situations and experiences and trauma that they experience and are exposed to certainly need a program such as Committee Substitute Senate Bill 64. Thank you again for bringing this bill up for us to consider and pass.
Thank you, Senator.
Senator Colcourse, what purpose?
Thank you, Mr. President. Does the senator yield for a question?
Certainly.
Thank you. Senator, thank you for this bill. It was a pleasure to have it laid out in Senate Health and Human. And I guess my question to you was, through the pandemic and the pressures that we've seen with our first responders and our law enforcement, do you think it could be even, it couldn't be more timely, could it?
It could not be more timely. Unfortunately, the added pressures of the COVID era, I think, have even compounded the mental health needs, not only of law enforcement, but as you well know, of our whole society. And I think having this available to our law enforcement is even more important than ever.
And I know, we're in the middle of budget and everything else, and this as just a tiny fiscal note that you had included in the base bill as well, right?
It is included in the base bill.
Yeah. So I really appreciate that, and I think that this is going to do a lot And Senator Hinojosa, thank you. Like y'all discussed about the veterans model, and this may be something that we build upon. I've had a lot of people in the medical profession talk to me about the stresses that our medical personnel has seen through COVID-19. And so we're going to keep making these steps in helping people be not only physically well, but mentally well. And thank you so much for your leadership on this issue.
Senator Nelson, you're recognized to suspend the regular order of business.
I've moved to suspend.
Any objection? Hearing none. The rules are suspended. Chair lays out on second reading. Committee substitute for Senate Bill 64. Secretary will read the caption.
Committee substitute Senate Bill 64 relating to a peer support network for certain law enforcement personnel.
You're recognized on a motion to engrossment.
I move passage to engrossment.
Any objection? Hearing none. Bill passes to engrossment. You're recognized to suspend the constitutional 3-day
I
ruling.
move to suspend the constitutional rule that bills be read on 3 several days.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
31 ayes, no nays. Rules suspended. Chair lays out on third reading and final passage. Committee substitute for Senate Bill 64. Secretary will read the caption.
Committee substitute Senate Bill 64 relating to a peer support network for certain law enforcement personnel.
You're recognized on final passage.
Thank you, Mr. President. Members, I move final passage on Senate Bill 64.
Secretary will call the roll.
Alvarado, Betancourt,
31 ayes, no nays. Bill's finally passed. Congratulations. There you go.
Thank you, Mr. President. Thank you, members. Thank you.
Senator Lucio, you're recognized. Committee substitute for Senate Bill 394 to suspend the regular order of business.
Thank you, Mr. President. Mr. President, members, currently abortion-inducing drugs are part of the Food and Drug Administration's risk evaluation and management strategies programs on REMS, R-E-M-S, due to their serious safety concerns. As administered under REMS, these drugs are not permitted to be prescribed and delivered through the mail. Senate Bill 394 brings down the mandatory in-person prescribing and sale of these drugs. In case the federal regulations change, Texas will still recognize that these drugs do pose serious risk for the women who take them. Many argue that these drugs are safe and serious adverse events are rare, but I believe this is because of the current regulation and close doctor oversight. Doctors need to be present when patients receive these drugs so that the patient knows what to expect from normal side effects and what needs to be addressed quickly before it turns into a serious issue. I will have an amendment that clarifies the restriction is only when providing it to the patient and not from the manufacturer to the physician. Move suspension, Mr. President.
Members, motion is on suspension. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
There being 19 ayes, 12 nays, the rules are suspended. Chair lays out on second reading. Committee substitute for Senate Bill 394. The Secretary will read the caption.
Committee substitute Senate Bill 394 relating to abortion complication reporting and the regulation of drug-induced abortion procedures.
There is an amendment. Secretary will read the caption.
For amendment number 1 by Lucio.
You're recognized on your amendment, sir.
Thank you, Mr. President. This amendment, members, inserts the words, quote, to the patient, unquote, to make sure this bill does not restrict the delivery of drugs from the manufacturer to the physicians. I move adoption, Mr. President.
Members' question is on the amendment. Are there any objections? Hearing none. Amendment is adopted. You're recognized on passage to engrossment.
So moved, Mr. President.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Seliger, Springer, Taylor, West, Whitmer, and Zaffarini.
There being 19 ayes, 12 nays, the bill passes to engrossment, and we will hold there until tomorrow.
Thank you, Mr. President.
Senator Paxton, you're recognized to suspend the regular order of business on committee substitute for Senate Bill 9.
Thank you, Mr. President and members. I move to suspend the regular order of business to take up and consider the committee substitute to Senate Bill 9. In the event and to the extent that the Supreme Court reverses its rulings under Roe v. Wade and Planned Parenthood versus Casey, abortion lawmaking authority would return to the states. Senate Bill 9 seeks to ensure that if this happens, Texas has a mechanism in place to end the loss of innocent life through abortion as soon as possible. Currently, 10 other states have enacted similar pieces of legislation. Senate Bill 9 would go into effect 30 days after the Supreme Court issues a judgment and a decision overturning, either fully or in part, the decisions handed down in Roe v. Wade or Planned Parenthood versus Casey, thereby taking effect to end the practice of abortion to the extent allowable under the new precedent. As proposed, the committee substitute to Senate Bill 9 amends current law relating to prohibition of abortion, provides a civil penalty, and creates a criminal offense. Of course, there's no criminal offense for any woman obtaining an abortion, and there is an exception for the life and health of the mother. With that, Mr. President, I move to suspend.
Senator Alvarado, for a purpose.
Thank you, Mr. President. To ask the author some questions.
Do you yield?
Of course.
Senator Paxton, you and I have debated this issue before, going back to last session, and you and I have bonded over a few things, and but this is one issue where I just, I know that Texas has some of the toughest laws on abortion. Would you agree?
Well, I think that would be perhaps one way to look at it. I think another way to look at it, though, would be to say that it has some of the strongest protections for the unborn.
Because when you Google it, it's, and you research states that have the strictest or strongest laws on abortion, Texas is always in the top. So I don't know. Every session, it seems like there's more that y'all come up with to do, and I just don't know where it stops. I don't know where it ends. Is it correct that SB 9 does not include an exception for mental illness in terms of a risk to a woman's life?
The bill is designed to give an exception in the case of the life of the mother or severe physical impairment to major organs.
Okay, so mental health is not included in that?
Correct.
Do you know how many Americans struggle with mental health?
I don't know that any of us know, for many reasons.
Yeah, 1 in 5, and mental health is very much a part of the Republican platform. If you look in the national platform, state platform, it's sprinkled throughout several places in the Republican platform. So I'm disappointed to see that there's not consistency, that mental health is not included here. Why did you choose not to include serious mental illness or risk of self-harm as a threat to a woman's life in the bill?
I think this is an issue where sometimes I think people, as we debate this, we start in different places. And the life of the mother is incredibly important, as is the life of the unborn child. It's a difficult situation. It's a difficult situation for a woman to be in. It's a difficult situation for, as Senator Hughes mentioned, a child who is at the most vulnerable time in their existence and has no ability to protect themselves.
Okay. If a doctor diagnoses a woman with a dangerous pregnancy complication, does this bill require them to wait to provide treatment until their condition deteriorates enough to threaten their life?
Could you repeat the question? I'm not sure that I heard it.
Sure. If a doctor diagnoses a woman with a dangerous pregnancy complication, does this bill require them to wait to provide treatment until their condition deteriorates enough to threaten her life?
So in the section 170A, 002, with the exceptions, basically what this says is that in the exercise of reasonable medical judgment, if the pregnant female on whom the abortion is performed, induced, or attempted has a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death or poses serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. That is the exception. And so that would be the determination of the physician and the woman. Again, what we're balancing here is not just one person's life. A woman's life and the life of an unborn child.
Senator Paxton, do you think that reproductive health care is essential to a woman's overall health?
I do.
But yet we continue to regulate and regulate and regulate women's reproductive health care. Heck, we regulate it more than ERCOT is regulated.
Not anymore.
Well, that just happened today. Do you know that major medical organizations consider access to abortion an important component of reproductive health care?
Many people would agree that health care is about life, about promoting health. And I think this is a place where there's philosophical and scientific disagreement for some people, me being one, and that is that health care is reserved for things that promote and enhance life, not for things that by design cause a death. And there's no getting around that every single abortion, by definition, is designed to cause the end of a life.
Well, I mean, I would argue that point and say that reproductive health care does include access to abortion because it could mean a lot of things to a lot of different women. And I don't want to get into the very specifics about that. But we seem to be, again, finding a solution for a problem that doesn't exist. And that's why you have organizations like the American College of Obstetricians and Gynecologists, the American Medical Association. These are the experts. Do you take into consideration their opinion? The field that they are experts in, did they have input into your bill?
This bill is about a fundamental question, and it is the value of the unborn child, roughly half of whom are women to be. Their life matters too. And it is the most difficult thing I can imagine to be in a place like this. And Senator, I'm sure that we've talked about this at some point. I'm an adopted child. My life began under circumstances that might very well have led to an abortion. I'm very grateful that my birth mother chose life for me. I could not choose it for myself, and neither can thousands and thousands of little babies. I was struck as we talked about honoring our Vietnam veterans, and the loss of life during that terrible conflict. I believe 55,000. The number I saw for 2019, lives lost to abortion, was over 58,000. This is not a problem that doesn't exist. And I hope you know, as we've talked in other times, I'm committed to women's health care. But I'm committed to women's health care after birth and before birth, for each of those little baby girls to have a chance to be born. And this is the question: how do we put less value on any life?
You mentioned a key word in your statement earlier, choice. It ought to be a choice. Choice is giving somebody the liberty and the freedom. Senator Hughes, in his prayer today, used those words, liberty and freedom. But yet, when we're talking about women's health care, some in this chamber become very selective when we're talking about liberty and freedom. And you mentioned looking after before and during, after birth, before and after. Let's talk about that then. Why aren't we talking about giving more people access to health care, expanding Medicaid? That could save lives. Would you agree?
I believe that the health care issue is critical. And I have had conversations with you, Senator Johnson and I have had many conversations about how we navigate this. But this bill is about this piece. And it is about the life of the unborn child and the life of the mother, both. As we think about choices, as we think about difficult circumstances that any of us might face in our lives, I can't think of any where one of the alternatives to addressing our troubling situation is to end the life of an innocent party.
But in this, we are criminalizing the providers. These providers are part of a community that were frontline workers during the pandemic and remain frontline workers, and yet they're having to choose whether or not they want to choose saving their patient's life or go to prison. That's how we're rewarding our frontline workers, our healthcare providers. Since when did women's reproductive health care become a crime?
Well, again, abortion is designed to end a life, which is hard to describe that as health care, which is supposed to be about saving life. And doctors who are engaged in saving life have nothing to worry about in their practice. There's a certain practice we're discussing here. It's a practice that ends life. And in any other situation, I think it is something we all stand by, that it's considered criminal to end the life of another, especially of an innocent. To the extent that they are engaged in saving life, there's an exception for that.
Senator Paxton, what degree felony would this bill make performing an abortion?
It would be a second-degree felony to perform an abortion. If the baby dies, it is a first-degree felony.
What is the fine for performing an abortion under this bill?
$100,000.
What is the fine for sexual assault in Texas?
I'm not aware.
Maximum $10,000.
Let's talk about that.
Well, yeah, I have a lot to say about that, but why would we punish a doctor who performs an abortion on a victim of rape or incest more than the actual rapist?
I would say that the problem here is not the amount of the fine on the doctor, but on a rapist.
This bill is called a trigger bill, so it might happen. So I don't know why we're spending time on something that might happen. We have so many larger things facing us. A pandemic, 45,000 Texans that have lost their lives. Millions, over 5 million people that are uninsured in this state. And in your layout and in your statements, you talk about saving lives, but yet a bill to expand Medicaid, to give people more coverage, to save lives, we don't debate, we don't discuss. I feel for the providers in this business who will fear going to prison. We have people in the medical field on this floor. I would not impose that on them.
I think that would be their choice. If the doctors would choose to use their profession to save life or to end life. And when we think about the 45,000 Texans who've lost their lives from the pandemic, I want to remind us all that, again, in 2019, upward of 58,000 babies were aborted. And that is why this bill matters now. The legislature can make law while we are in session. But we have an interim of about a year and a half. And should something happen at the Supreme Court during that time, it matters that immediately lives can be saved. That no innocent life is lost because we're waiting for the legislature to come back into session.
Yeah, and we can debate where people stand on abortion, where they stand on choice. But to criminalize the men and women who work in this field, I don't know how this body can endorse that. And the discomfort that it gives those providers going to work knowing that should this be enacted, that they could go to prison for being involved, for being a provider of women's reproductive health care. You know, we celebrated and still celebrating Women's History Month. We celebrated last year the 100th anniversary of women having the right to vote. We celebrate that there are 10 women in this body. More than ever. History, right? Celebrating all these great things in history for Texas women. In generations to come, in the year 2020, I'm curious to see how that history will be written. 10 women in this body. I'd sure like to make something happen with that one of these days. Something meaningful. something we can all hang our heads high, and know that we made our place in history. Thank you.
I look forward to doing that with you, Senator Alvarado. Thank you.
Senator Johnson, for what purpose?
Question of the author.
You yield.
Of course.
Real briefly, Senator Paxton, do you have any sense of how the issue of whether or not Texas abortion laws should be stricter or less strict polls in Texas right now?
I think you might have a chart.
I would like to share one, and polls are polls, and they're not all that accurate all the time. But the most recent poll that I've seen from February of this year says that 55% of Texans think that abortion laws should either be left where they are or less strict, and only 32% think they should be more strict. Now, there may be other numbers, but we have another set of numbers that only 13% of Texans think that abortion should be banned in all cases. And your bill makes no exceptions for rape or incest. So I ask you, instead of a trigger bill, isn't there a bigger conversation we need to have when it truly is up to the states to ban abortion? Because right now, it's at least equivocal whether we ought to have an outright ban on abortion and whether Texans support that. So let's let Texans express their voice perhaps at the next election while we talk to our constituents about how they feel about this rather than prejudge it for them.
Well, I guess I would say that for every study that says one thing, you can find a study that says something else. So without having a lot of context there, it's hard to say that is a conclusive and exhaustive assessment of where people are. Right. But at the end of the day, what this is about is protecting human life from conception through birth, and as Senator Lucio said, until natural death.
And I know that that's what it's about, but in terms of if Texas is going to enact a law that in some way prohibits abortions, I feel like we ought to have a more measured discussion about it than simply a trigger that takes place without consulting this body or our constituents. That's my opposition to your bill. Not any doubt about your intentions. I understand the respect that all of us have for the sanctity of life, and I appreciate it. But I think this bill takes away the legislative process that should happen when it's time to happen.
I would simply say, I appreciate your question. I would simply say that I think that everyone here pays attention to this issue with relation to their constituents. I know I do. I know all of us have constituents on both sides of the issue. But I think that we come here today with a sense of where our constituents would have us vote. And I'm sure that's what we'll do today.
But it is in the abstract. And when I think about what I might do tomorrow and make that decision today, tomorrow's a different day, and I might see it differently. And I'm suggesting that we should make tomorrow's decision tomorrow, not today.
Thank you.
Senator Paxton moves to suspend the regular order of business. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
19 ayes and 12 nays. Rules are suspended. There is an amendment. Chair lays, I'm sorry. First, we got to lay the bill out on second reading. Committee substitute for Senate Bill 9. Secretary will read the caption.
Committee substitute Senate Bill 9 relating to prohibition of abortion.
The following amendment, Secretary will read the amendment.
Floor amendment number 1 by Hughes.
Senator Hughes, you're recognized.
Thank you, Mr. President. Members, this amendment is legislative finding, as Senator Johnson and I discussed, and consistent with testimony before the committee about the laws that exist already in Texas before the Supreme Court's ruling, and consistent with the bill and acceptable to the author. I move its adoption.
Members, the question is on the adoption of the amendment. Any objection? Hearing none, amendment is adopted. Senator Paxton, you're recognized on passage to engrossment.
So moved.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Saliger, Springer, Taylor, West, Whitmer, and Zaffarini.
There being 19 ayes, 12 nays, the bill passed to engrossment. We'll hold there until tomorrow. Thank you, Senator.
Thank you, Mr. President. Thank you, members.
Senator Perry, you're recognized. Committee substitute for Senate Bill 1647. Suspend the regular order of business.
Thank you, Mr. President and members. Senate Bill 1647 is a composite or an omnibus bill of the last three that you've heard. Specifically, it contains Senate Bill 1173, Senate Bill 9, and Senate Bill 8, the heartbeat bill, the abolition bill, and the PreNDA bill. So pretty much have heard the arguments for the bills and the questions and answers. There are a couple of differences in the bills today. Nothing changing substantially. On the 1647, we do introduce the terms viable preborn to preborn. We do add induce to perform or induce an abortion. The heartbeat bill will have an amendment on it that I will accept from Senator Hughes that will clarify some of those differences that were there just through Legis Council. Additionally, I do have an amendment that will clean up. Back in the Sonogram Bill, we had language there for a 100-mile, 2-hour waiver process. We're going to make that consistent with the PreNDA bill that Kelly Hancock laid out to maintain consistency throughout the code. With that, I move to suspend the regular order of business.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
There being 19 ayes, 12 nays, the rules are suspended. Chair lays out on second reading, Committee Substitute for Senate Bill 1647. Secretary, read the caption.
Committee Substitute Senate Bill 1647 relating to information regarding perinatal palliative care, regulation of abortion, and the availability of certain defenses to prosecution.
There is an amendment. Secretary will read the amendment.
Floor Amendment number 1 by Perry.
Senator Perry, you're recognized on your amendment.
Thank you, members. In 2011, during the 82nd session, Texas passed the Sonogram Bill. The bill allowed for a sonogram to be performed 2 hours to an abortion in lieu of the 24 hours if a woman seeking an abortion lived more than 100 miles away from the licensed abortion facility. This is reflected in Senate Bill 1173, Senator Hancock's PreNDA bill for informing the women of unborn babies' diagnosis of a life-threatening disability. This amendment mirrors the Sonogram Bill language in SB 1173 pertaining to the 100-mile exception. Basically, we waive the 24-hour requirement if you're 100 miles or further from the abortion provider. Second, this amendment adds the trigger language found in the Abolition Bill of Senate Bill 9. With that, move adoption.
Any objection to the amendment? Hearing none, amendment is adopted. There is an amendment. Secretary will read the amendment.
Floor Amendment number 2 by Hughes.
Senator Hughes, you're recognized on your amendment.
Thank you, Mr. President. Members, as Senator Perry explained to us, his bill is a composite of other pro-life bills that have passed with some important additions. And so what's before you is the exact version of what we just passed earlier in the heartbeat bill. So for that heartbeat bill section of Senator Perry's bill, this amendment would conform it to the bill the Senate just passed. That's what it does. I'm happy to go through it again. That's what it does, and it's acceptable to the author, and I move adoption of amendment number 2.
Senator Alvarado, what purpose?
Mr. President, to ask the author a question.
Do you yield?
Of course, I'll yield.
Senator Hughes, your amendment is 24 pages.
The amendment is, I believe, let me make sure. I'm sure you're right. I'm sure you're correct. Yes, 23 and a half, but that's right.
I'm sure it's not going to change how I'm going to vote on this, but I would certainly like to talk to you about it, or at least take a look at it.
I can certify to you that it is word for word, line for line, what the Senate just adopted in Senate Bill 8. Senator Perry's filed bill was the filed version of Senate Bill 8. This is the version that was just passed by the Senate. But of course, take a look. If I'm wrong, you tell me, but that's what this amendment is.
Are there any other amendments coming?
This is the only amendment I'm offering on Senator Perry's bill.
There are no other amendments. There are no other amendments.
Okay, well, I'll take a read. Like I said, I'm sure it's not going to change my mind on this bill, but I certainly would. It is rather lengthy, so I'm going to skim through it.
Yeah, so the heartbeat section of Senator Perry's bill is lengthy, and the amendment's lengthy because this conforms that section to the heartbeat bill that the Senate just passed. But go ahead. If that answers your question.
We'll give Senator Alvarado some time. You know, Senator Perry, you said something that was kind of startling to me for a moment. You said we passed the Sonogram Bill in 2011. It took us 5 hard years to pass it. We started it out here in 2007. It's now been 10 years, and I don't know the exact numbers, but the estimate is 15 to 20,000 lives have been saved every year once it became implemented. That means that bill has saved well over 100,000 Texans.
Yeah, that was a game changer, for sure. And I'm sorry about the amendment. Senator Hughes and I had been working back and forth, and the tweaks that it was just easier to just do it lay on top. So
we'll give Senator Alvarado some time. Senator Alvarado.
Thank you, Mr. President. And I don't have any comments or questions on Senator Hughes' amendment, but on the previous amendment by Senator Perry, it included the language of Senate Bill 9, and you asked if there were any objections, and it all came so quickly. I don't think any of us had a chance to register our objection to it.
Okay, I did give plenty of time to register an objection to it. I wasn't trying to rush anything. I always looked both sides.
Okay.
So, but you can feel free to change that.
Okay, I will do that. Thank you.
And any other senator who wishes to do that. It won't change the outcome of the amendment, but. So the question is on the adoption of floor amendment number 2 by Hughes. We'll call the roll. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Sulliger, Springer, Taylor, West, Whitmire, and Zaffarini.
There being 19 ayes and 12 nays, the amendment is adopted.
All the D.
Senator Perry, you are recognized on motion to engrossment.
I'll, Mr. President, just make a comment or two before I do that motion. Heard a lot of conversations, and I've been down here 10 years or so, and these are never the bill days that you go home with and go, man, it's a good thing for the cause and for the life and the sanctity of life, but it's always hard because you know your colleagues struggle with some of these. But far too long, I have been a little too silent, as well as I think in general, with 58,000 Texans being aborted on annual and over 60 to 70 million in this nation. And if you put that in context, it's just hard to even get your head around. But people of faith and everybody's faith is their own personal belief system at some level. But if you believe in a sovereign creator and the freedom we speak to and the latitude and the gratitude of that freedom, you can't separate it from the fact that he is the creator. And he would never condone and he will never support the intentional killing of an innocent child in the womb. There's no way you can reconcile that if you truly believe in a sovereign God. And that's what this is about at its core. What do we as a country, what do we as a state, and what do we as individuals believe? History is riddled with societies that have allowed their children, born or unborn, offered up as sacrifices. I call it the altar of self, and those societies are no longer with us. So as we have these days, and we'll have better days tomorrow as groups, but the issues are personal on so many levels. But I operate under a healthy fear of the God that created me and everyone on this floor, that there will be a day of reckoning, and the stain that this country has allowed to occur for far too long will be one that we can't wash away. With that, I move passage to engrossment.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell.
19 ayes, 12 nays. The bill passes on engrossment. We'll hold there. Senator Paxton, you're recognized on committee substitute Senate Bill 802 to suspend the regular order of business.
Thank you, Mr. President and members. I move to suspend the Senate's regular order of business to take up and consider the committee substitute to Senate Bill 802. The current informed consent law codified in Chapter 171 of the Health and Safety Code requires an abortion provider to provide a woman seeking abortion three things. Number one, the woman's right to know printed materials. Number two, that the father of the baby is legally liable for child support. And three, to notify her that medical assistance benefits, quote unquote, may be available to her. Senate Bill 802, the Every Mother Matters Act, or EMMA, builds out this third element. Instead of simply telling a woman that assistance may be available to her, Senate Bill 802 not only informs her of resources available, but creates a mechanism to provide an offer to match and connect her with that assistance. Specifically, Senate Bill 802 requires provision of an offer of resource access assistance by a third party to the pregnant woman prior to an abortion, with the third party being an entity under contract with the Texas Health and Human Services Commission. This person or party is called the care agent. The resource access assistance offer includes providing medically accurate information using the woman's right to know information that's provided by HHSC. It provides an assessment and offer of support services, including housing, employment, resume development, child care, medical care, adoption services, and health benefit plan coverage. It includes education on available state and local resources based on the woman's socioeconomic needs. And it matches her needs with the resources that are actually available. Finally, it also provides a screening in the case that the woman is actually the victim of crime, screening for family violence, abuse, and neglect victimization, coercion of abortion, and human trafficking victimization. Members, I have discussed a floor amendment with many of you to address a concern you brought to my attention regarding the mechanism for verification of the offer of resource assistance, and I will be laying out this amendment shortly. I move suspension of the Senate's regular order of business on the committee substitute for Senate Bill 802.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
20 ayes and 11 nays. The rule is suspended. Chair lays out on second reading committee substitute for Senate Bill 802. Secretary, read the caption.
Committee substitute Senate Bill 802 relating to a required resource access assistance offer before an abortion is performed or induced.
There is an amendment. The Secretary will read the amendment.
For amendment number 1 by Paxton.
Senator Paxton, you're recognized on your amendment.
Thank you, Mr. President and members. The floor amendment creates the two-factor authentication system for the generation and use of a PIN to verify the completion of the resource assistance offer without any development, maintenance, or use of a database. I move adoption of floor amendment number 1.
Senator Eckhart, did you have a question on the amendment?
I have a question on the amendment and the bill overall. May I?
Okay. You can ask the question on the amendment first. Senator Paxton?
Yes.
So with regard to the two-point access, the unique number goes away once it's confirmed by the physician, correct?
That is correct. It is consumable. So each number generated is unique, and it is obliterated from the system, although if it were to be reused, it would be flagged. It would not be able to be used more than once.
So the only point of the process is to guarantee that the woman has subjected herself to this counseling, whether or not she needs it, whether or not she's eligible for it, and whether or not there are actually services in her area.
The purpose of the PIN is to verify that the offer of assistance has been made by the abortion provider.
And so there will be no utility in this process with regard to determining the massive gaps in services available to these women across the state. Is that correct?
I'm not sure I follow.
Two-point authentication system has no utility with regard to identifying the massive gaps in services available to these women in their home counties, correct?
The purpose of the authentication system is that when the woman calls the toll-free number, she is given an offer to connect her with resources. She has the opportunity to accept that offer and connect with those, or to decline it. In fact, she can still have the abortion. In fact, she can still have the abortion and receive the services. So the purpose of the call is to connect her with those resources if she desires.
So these resources that these counselors are connecting these women to, are they funded through state revenues?
The care agents are under contract with HHSC.
And are they connecting the woman to services that are funded by state revenues?
Sometimes. There will be perhaps local resources, state resources that the woman is eligible for.
And this bill, as it's constructed, will dedicate the fiscal note is $7 million annually for the administrative cost, but does not dedicate any state resources to the pregnant woman. Is that correct?
Actually, the pregnant woman is eligible for services for up to 2 years.
But again, what services are you describing?
So back during the bill layout, one of the things that I listed there were the various types of services. The woman is provided with medically accurate information,
which is already provided by this pamphlet that's required under already existing law, correct?
So it also, though, when that is done on a phone call, part of what that allows the woman to have is actually interaction with the care agent if she were to have questions. Secondly, there's an assessment and offer of support services, including housing, employment, resume development, child care, medical care, adoption services, and health benefit plan coverage, education on available state and local resources based on her socioeconomic needs, and then matching those. And then, I don't know if you heard the end of that, but additionally, to screen if the woman is actually the victim of a crime, family violence, abuse, neglect, coercion of abortion, or human trafficking.
I did hear that, and I also read it in your bill. I will go back to my question, though, with regard to what these counselors are directing these women to. We currently don't even provide Medicaid to a woman who doesn't have children. No Medicaid whatsoever, correct? Correct?
I'll accept your comments.
And if the woman already has one child, she's eligible for Medicaid if she makes 17% of the federal poverty line or less, which is less than $18,000 a year, correct?
Continue.
Do you know that to be correct?
Well, I'm not sure what that has to do with the amendment.
What it has to do with the amendment is that we are directing these women to services that don't exist with a pin that has no other utility than directing them to services that the state doesn't provide.
Well, Senator, this bill is designed to connect them with resources that do exist. And
perhaps they're local resources or federally funded resources?
When I said yield, I guess I meant it.
I'm sorry?
Proceed.
Are you thinking of local resources, privately funded resources, and federal resources?
Any resources. They could be state or local resources that match the woman's socioeconomic needs.
And considering the extremely high bar for eligibility in the state of Texas, it being 17% for a woman who has a single child, and no eligibility for Medicaid for a woman who is not a parent, unless she's dying of something. Correct?
This bill is designed to connect women with resources for which they're eligible. And the idea here is that oftentimes women are not aware of the resources available to them. And so this bill is about giving women information that they might not have, connecting them to resources that they may not know exist. And even if they know they exist, they may not realize that they're eligible for. I also would like to make one other point, and these are not counselors they're speaking with in the sense of the way they're designed in the bill. These are care agents, but they are professionals, and it is their training to do this kind of work and to connect the women with resources for which they may be available and help them connect.
So we're going to spend $7 million annually for somebody who is less qualified than their doctor to give them advice on something that they probably aren't eligible for.
Well, I would say the fact that they're in this position, if they're interested in pursuing the resources and accepting the offer, then they will be the judge of that.
They get a choice, right?
Yes.
That's great. I have no more questions about the amendment, but I do have questions on the substance of the bill.
Senator, we'll go to the other members who have something to say on the amendment, and I can come back to you. Senator Seliger, did you have a question on the amendment?
Question to the author of the amendment.
Do you yield?
I do.
This amendment does something I think that was very important, Senator Paxton. There is no longer in this bill any semblance of a registry or anything like that, which I think is good. The original bill had 7 full-time equivalent employees and a $13 million fiscal note. What is that fiscal note today?
I do know that the fiscal note is less and it is decreased by this particular mechanism. And if I give me a second and I can get to that.
And I don't want to distract from the substance of your bill, and I know I am sort of.
That's all right. Yes, the 2-year net impact is 13.6.
Is that money in Senate Bill 1?
I'm sorry?
And so this bill stays with the 13 million?
Yes, if it is appropriated.
Explain to me, if you take out the registry, which was 7 people to handle the registry, what do those FTEs do now?
Well, the fiscal note is reduced by the amount of those FTEs. By about $160,000.
$160,000 out of the 13 million?
Yes.
It's always important to cut money. Would you accept an amendment that specifies that if the money is not appropriated, the bill does not go into effect? It was one time called the Ogden Amendment, then it was called the Williams Amendment, and then it's been called the Nelson Amendment, because if there is no money appropriated, the question then is, does your bill go into effect?
That is already the case.
I'm sorry?
That is already the case, Senator Seliger.
Okay, thank you.
Thank you.
Senator Lucio, for what purpose?
With Senator Paxton, yield.
Do you yield?
Of course.
Reminds me of the bill I was carrying the last session. What this bill does, if I'm reading it right, is it ensures that the materials will indeed be delivered to the woman seeking an abortion by creating this database, correct? By creating the database?
There is no database. There is no database.
There's no database.
There is an authentication PIN number that is used for that purpose.
Excuse me, I thought different for some reason. Is there anything else that is required of the woman in this connection that takes place? I'm sorry. I do have to return that one to my wife. Would there be an opportunity to receive other information? I have always wanted to, and the reason I'm bringing this up is because of the possibility of maybe adding to the bill in the process, of wanting to know specifically why the woman is seeking that abortion. Is it rape? Is it incest? Are there other reasons? I think it would really help us better understand what is happening at this time to the woman that is seeking this abortion. And it's important for us to have as much background as possible to see what can be done to make sure not only the materials that she receives can inform her, but maybe other things can happen along the way that would make her think about the abortion. And that's what I'm thinking.
Well, I think that's a really important point. And Senator Lucio, it doesn't surprise me at all for you to bring that up, because I know when you look at something like this, you don't look at it as some government program. You look at it as an opportunity to help a woman who's in a difficult situation. And your compassion is legendary, and I appreciate it and respect it so very much. One of the things we do know from those who do work with women who are seeking an abortion is that the top needs, and I've got some statistics on this which I think are interesting, and to your point, 73% of these women report that they have financial needs, and that is contributing significantly to their choice to seek an abortion. 70% say that they are in need of emotional, spiritual support and counseling. 64% say they're in need of employment. 59% of material assistance. 49% housing, and 45% insurance. And it's important for us to know these things about women in general, because that will help the care agents and those who will engage in this through Health and Human Services to tailor the sorts of things that they're looking for to provide to the women. They'll already know what the predominant needs tend to be.
Thank you for sharing that with me, because and for those listening, obviously there are many organizations. We're blessed with many organizations in Texas that will address each one of those that you just identified as reasons why women are seeking this abortion. I hope we can continue to work through the process to make sure that you have a very strong bill. I support it. Thank you.
Thank you, Senator Lucio.
Senator, we're going to adopt this amendment first. So the question is on the adoption of the amendment. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham.
There being 20 ayes and 11 nays, the amendment is adopted. There is an amendment. Secretary will read the amendment.
For amendment number 2 by Eckhart.
Senator Eckhart, you're recognized to speak on your amendment.
Thank you so much, Mr. President, and thank you to the senators. What this amendment is designed to do is to make the care navigators Health and Human Services employees rather than third-party contractors. We have a Health and Services Department. They already provide mandatory information under existing state law, and this amendment would simply take out essentially a profit motive for a third-party contractor and keep this in-house.
Senator Paxton, on the amendment.
With respect, I would oppose this amendment. I believe that the structure that we have in place allows for much more creative approach to the care. It doesn't pull current employees from Health and Human Services away from the work that they're already doing and increase the costs there.
Members, the question is on the amendment. And the secretary is filling the blanks based on your information to her. Members, there are, call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes.
There are 12 votes in favor, 19 against. The amendment fails. So, Senator Eckhart, you wanted to ask more questions on the bill. Had you asked questions already?
I have a couple more questions on the bill itself.
Do you yield, Senator Paxton, for a few more questions?
Of course.
You're recognized.
Thank you so much, Mr. President, and thank you, senators, for indulging me on just a couple more questions. Senator Paxton, I very much appreciate your previous amendment, although I didn't vote for it. I do appreciate us not having a statewide database. It does seem to be a fairly heavy infringement on a woman's privacy. But the two remaining provisions, that a woman submit to state-sanctioned counseling and evaluation for additional services, whether or not she seeks them, whether or not she is qualified for them, whether or not they actually are available in her area. And the second provision, that a physician withhold medical treatment unless and until it's confirmed that she has availed herself of this counseling. Those two requirements seem to be still a very heavy intrusion What other legal medical procedures do you believe this level of state involvement is appropriate, or even we already engage in? Do we have any other examples other than abortion where the state involves themselves this heavily?
Senator, I'd have to go back to the first part. The woman is not required to avail herself to share information, to pursue counseling or to engage in counseling. All this bill does is it requires the abortion provider to provide to the woman the connection so that she can be made aware of any available resources for her situation. If she wants to call and say, this is my verification code, and they say okay, and she can hang up. That's it. So there is no requirement on the woman. It is based on data that we have that 3 out of 4 women, 75% of women seeking an abortion, say that if their circumstances were different, they would choose to carry the baby to term. And when we know that 3 out of 4 women who actually get to the place where they step into the office to pursue an abortion, and we know 3 out of 4 of those women are saying, this is not my first choice, I just don't know what else to do. The worst thing to me is to not be willing to say, there may be things that are available to you that you just don't know about.
If the woman calls, if the woman does not call and listen and hang up, what enforcement action is the state prepared to take against her for failing to call, listen, and hang up?
There is no enforcement against the woman, but the abortion provider cannot provide the abortion until that's been done.
So the enforcement provision is that for failing to call, listen, and hang up, she cannot access an otherwise perfectly legal and safe abortion.
What is legal is what we determine to be the law.
I said otherwise. So, but for her calling, listening, and hanging up, she cannot access a legal and safe abortion that a doctor is willing to provide.
If this bill passes, this would be the law.
That's why I said, and otherwise, laying aside this bill says that if you don't call and if you don't at least call, listen, and hang up, you cannot get an abortion, correct? So that's a fairly heavy enforcement mechanism.
Or you could say, if you wish to have the abortion, you just need to call this number.
So if a physician provides an abortion to a woman without confirming that she has submitted to the state-sanctioned counseling and evaluation, regardless of whether she wants the services, is eligible for the services, or the services are available to her where she lives, what enforcement action is the state prepared to take against the physician?
The physician would be in violation of the law.
And what would be the cause of action against the physician? What would be the penalty against the physician?
That is a good question, Senator. If you wouldn't mind me touching base with my staff on that real quickly.
Fine, and I can go to my next question. Can you think of any other legal medical procedures that should have this kind of mechanism where a patient should have to check in with Health and Human Services or a contractor of Health and Human Services and the doctor should have an obligation to assure that that has been done?
I think as we've listened to the debate on the floor and the discussion on the floor today, there is a reason that abortion is heavily regulated.
I'm asking for a circumstance other than abortion, though. Can you think of any other instance where a patient should have to check in with Health and Human Services and a doctor should have an obligation to assure that they have checked in with Health and Human Services?
I'm not aware of one, and I'm also not aware of another medical procedure that causes the death of another human being in its execution.
Do you think that this level of state involvement would be appropriate to curb infection from a deadly virus? We have experienced over 48,000 deaths from COVID-19, and to my knowledge, we have not created an obligation of a patient to check in with Health and Human Services. We've not created an obligation for a physician to verify that they've checked in with Health and Human Services, and we've not required any state services, have even curtailed some local services to individuals during quarantine.
And that is not the purpose of this bill. Perhaps you have another bill on that note, I don't know. This bill is to help women who are in a position where they're seeking an abortion, a situation where we know 3 out of 4 women wish there was another way. And it is simply to create an opportunity for them to know, is there another way? Are there other resources that would help me? It's up to them to choose to take advantage of those or to choose to stay the course. Either way, these women, if they are interested in these resources, whether they have the abortion or not, they are eligible for this help. That's what this bill is about.
I think that most women in the state of Texas will see this as a barrier masquerading as assistance. But thank you for removing the statewide database. I appreciate that.
Thank you, Senator. The motion is on passage to engrossment.
So moved.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
20 ayes, 11 nays. The bill passes to engrossment. We'll hold there until tomorrow.
Thank you, Mr. President. Thank you, members.
Senator Campbell, you're recognized to suspend the regular order of business on Senate Bill 650.
Thank you, Mr. President. I move to suspend the Senate's regular order of business and take up and consider SB 650. Last session, we had SB 22. It passed, and the purpose was to prevent local and state taxpayer dollars from funding the abortion industry. A loophole exists, and that's interpreted to allow logistical support for abortion. SB 650 plugs the newly found loophole that government's using to logistically assist abortion services. With that, I move suspension.
Motion is on suspension. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
19 ayes, 12 nays. Rules are suspended. Chair lays out on second reading Senate Bill 650. Secretary will read the caption.
Senate Bill 650 relating to prohibited logistical support by a governmental entity for procurement of an abortion or the services of an abortion provider.
Following amendment, Secretary will read the amendment.
Floor amendment number 1 by Eckhart.
Senator Eckhart, you're recognized on your amendment.
This amendment is asked just for the striking of the or the services of an abortion provider. I take Senator Campbell at her word that she doesn't want to fund an abortion industry, but I'm assuming she doesn't want to fund an anti-abortion industry as well. This is simply to take out the phrase or the services of an abortion provider because those individuals may want to work in this area.
Senator Campbell, you're recognized on the amendment.
This amendment is not acceptable to the author.
Members, the question is on the adoption of the amendment. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Sulliger, Springer, Taylor, West, Whitmire, and Zaffarini.
The amendment fails. There are 19 no votes, 12 yes votes. Members, there is an amendment. The following amendment, Secretary will read.
Floor amendment number 2 by Eckhart.
Senator Eckhart, you're recognized on your amendment.
This section is designed to acknowledge that the governmental bodies at the local level are elected, and so they do represent the will of the people. And so it would say this section does not apply to a governmental entity governed by an official or a body of representatives who are duly elected by the people, so that we would not be substituting our decision for the locally elected body who has chosen to provide these services.
Senator Campbell, you're recognized on the amendment.
Thank you. The amendment is not acceptable to the author.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
There are 19 no votes, 12 yes votes. The amendment fails. Following amendment, the Secretary will read the amendment.
Floor amendment number 3 by Eckhart.
Senator Eckhart, you're recognized.
I have to remind myself what this one is.
Take your time.
There's a lot going on today.
Yes, ma'am.
It's removing section 2. Oh, this is just to remove the Attorney General from the equation.
Senator Campbell, you're recognized on the amendment.
The amendment is not acceptable to the author.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
19 no votes, 12 yes votes. The amendment fails. Senator Campbell?
I move passage to engrossment.
Secretary will call the roll.
Alvarado, Betancourt, Blanco, Buckingham, Campbell, Creighton, Eckhart, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, Colcourse, Lucio, Menendez, Miles, Nelson, Nichols, Paxton, Perry, Powell, Shortner, Sulliger, Springer, Taylor, West, Whitmire, and Zaffarini.
Be 19 yes votes, 12 no votes. The bill passes to engrossment and will hold until tomorrow.
Thank you, Mr. President. Thank you, members. Thank you, Senator Eckhart.